everyone, and welcome back to the OKT podcast. Today, we bring you an episode on what in Ontario we've called Bill 5, and the federal version is C-5. To add to the confusion, both bills have become law already, so they're not technically bills anymore. But because everybody has been used to calling them Bill 5 and Bill C-5, I suspect that's what we'll continue to do, at least for the purposes of this show. So there's Ontario's Bill 5, there's the federal Bill C-5, and British Columbia has a similar piece of legislation. And I'm sure you've heard about these bills. They've been sold as a way to deal with the effect of Trump policies down in the States. And what they do is create exceptions to the environmental law regime. And in recent years, the duty to consult Indigenous communities has also become a big part of project approvals in Canada. So for all of us who are interested in Indigenous rights law, in environmental law, in project approvals in general, this is quite an opportune time to talk about all these things and to think about them together. So, big questions. What are the changes that Bill 5 and Bill C-5 are implementing? How does that change the landscape for project approvals, and what does it mean for Indigenous jurisdiction over their land? Today, I've got an all-star group here to share their knowledge with you. I'll start off by introducing myself. My name's Senwung Luk. I'm a partner at OKT. I practice in litigation, focusing on Section 35 rights and enforcing benefit sharing agreements under impacts and benefits agreements. So I'm joining you from Toronto, and I've got Randall Kahgee, who's a senior counsel at OKT. Not only is he a practicing lawyer, but he has also been chief of Saugeen First Nation, as well as a commissioner at the Canadian Nuclear Safety Commission. He has extensive experience in environmental law and consultation and accommodation. He's joining us from Saugeen First Nation. And I've got Martin Olszynski. He's a professor at the University of Calgary Faculty of Law. Before that, he practiced law at the Department of Justice with the federal government. He has published widely in environmental law. He's currently a member of the Federal Ministry of the Environment and Climate Change Canada's Advisory Council on Impact Assessment. He is joining us from Calgary. And we've got David Wright, who is also a professor at the University of Calgary Faculty of Law. He has also published widely in natural resources law, environmental law, and Indigenous rights law, with a special focus on modern treaties and their implementation. He is on the roster of experts for appointment to the Federal Impact Assessment Act review panels. He's joining us from Calgary today as well. So before we start, I'm going to note that the phrase in the legislation, national interest projects, gives us an acronym that is a racist term, which I won't repeat here. This fact was pointed out to both chambers of parliament, but unfortunately they have not done anything to rectify the situation. So I'm going to suggest to our speakers that if they want to talk fast and refer to that idea using an acronym, that they can use PINI, P-I-N-I, to refer to projects in the national interest. All right, so let's start out with a question for David and Martin. Bill 5, Bill C-5, they're about creating exceptions. So before we talk about these exceptions, can you tell us a bit about how we got to this point? What's environmental law and how do projects get approved?
Why don't you take the lead, Martin? I'll hop in.
Sure. And if I can add just a small addendum, Sen. So yesterday, a senator from Alberta, Paula Simons, she started to call them ponies, projects of national interest. And then she made some wonderful sort of allusions to Pink Pony Club and things like that. So we can talk.
Yeah, and My Little
Pony, also not racist.
And My Little Pony jokes just flow naturally too, so it's even better. You trot them out.
Yeah, so I mean, I think that the story starts about 50 years ago, 55 years ago in the United States with the first sort of like the progenitor of all environmental assessment laws. In fact, it was the first law that sort of kicked off a decade of environmental lawmaking in the United States that's since been followed basically by every Western jurisdiction. And it was the National Environmental Policy Act, or NEPA, which set out a system, essentially a process for agencies and government departments to inform themselves of the environmental consequences of their decision making. And this was out of a recognition that, prior to that point, governments had done a pretty miserable job actually of taking, they were very good at taking economic considerations into account, political considerations into account, especially short-term ones, but they weren't very good at taking into account environmental considerations. And so the goal of this legislation, in a blog on C-5 that David and I posted early in this discussion, he describes it as a look before you leap law, right? So the point is just to force governments to inform themselves and to disclose in a transparent and public way to the public, and both in terms of like in the immediate vicinity of these projects, but also maybe further out, about the environmental consequences of these projects. But I think it's also important to say that these laws have not ever really been substantive. So, even though they do compel governments, agencies, departments to look at these environmental consequences, they seldom draw any kind of bottom line or sort of a substantive limit on the amount of harm that might be allowed. Generally speaking, it was the case then, and it's the case now, that these projects can almost always be justified or approved under some sort of like some form of public interest test. And so that's where we are. We've been doing that for about 50 years in Canada. Really, it took off in the 80s, and we had our first legislated environmental assessment law in the 90s. But it seems like the minute we had it, we started to try to tear it down. And this is probably just a further manifestation.
And Martin, you're referring to that wonderful blog post that you and David authored. That's on the Alberta Law blog, or AB blog, ABLAWG, which I encourage all of our listeners to go have a look at. David, anything to add?
Yeah, I think that's a good sort of walkthrough by Martin. To that, I would add that one way to look at environmental law is in waves, and there's been evolution over the decades from, first of all, just common law roots and things like nuisance to statutory law that was more command and control end of pipe, and then slowly evolving to go up the chain of decision making toward impact assessment, also known as environmental assessment. That's the look before you leap. And so the idea is that we've actually gotten more wise and intelligent about how we look at projects, to a point where we created a framework where you could take a comprehensive look, understand what the risks were in a very high level way, and then avoid the worst ones and mitigate and so on. What's interesting about what's happening right now is we've been you could argue that, at least on paper, the laws have been evolving in a relatively good way. This may be one of the first big steps back. And you could argue that started actually in 2012, about 10 years ago. But the evolution is starting to lead into regression, which is quite alarming. We can get into specifics of that. But to your question, what is environmental law? That's what it is, where it's come from. But the sad truth is where it's going is pretty dark at the present time.
So, Randall, I'm going to ask you, you're a lawyer, you've been a member of the Nuclear Safety Commission, you have been chief and counselor. So you've seen this puzzle from many sides. So can you walk us through how these environmental impact assessment processes, how they interface with Indigenous jurisdiction and the duty to consult?
Yeah, sure. No, thanks for that, Sen. And I like the remark that David made earlier in the context of where we find ourselves in the law right now with this introduction of these new bills. I think he said it right. It's a huge step backwards. And I think from an Indigenous perspective, that's extremely frustrating, because a lot of the times when we deal with these types of issues, it's a constant fight to not only be heard, but also to make sure that we're recognized and fundamentally our voice is being recognized in those processes. And more importantly, that our our respective nations and communities are in the best possible position to make informed decisions about projects that are being proposed for our territories. And so, this is the fight, and for whenever we seem to make progress on these things, someone's always changing the rules, or they change the goalposts, and that's extremely frustrating. And so, we look at it. I step back, and I always go back to first principles. And obviously, I can't speak for all the treaties and the country, but I step back and I look at it through the lens of their treaty partnership that's supposed to exist, and resist the urge to kind of take this impoverished view that typically has been adopted historically, that these were just mere land transactions and nothing more. But there was a spirit and intent with those treaties, and what was to govern our relationship with the Crown prior to those treaties being made. And it was understood that our relationship was supposed to be predicated on mutual respect. Our relationship was supposed to be nation to nation. Neither would interfere with the path of the other. And what mattered most to our people, first and foremost, was protecting and maintaining our relationship to our lands and waters, and making sure that relationship was sustainable for many generations to come, because who we are as a people, who I am as a Anishinaabe, is inextricably linked to that relationship. Our language, our culture, our ceremonies, indeed our very identity. And so when we're faced with these projects, what we have seen historically, and I'm sure my friends would agree, a lot of times these developments proceed at the exclusion of First Nations. It's only in the last several years we're starting to see some progress where things are shifting on that. But for the most part, we've been excluded and left on the outside looking in. And with that comes a long list of concerns and fears about how those historical projects have interacted with those things that are important to us. And those questions need to be addressed. And it's not always as simple as looking at one project in isolation. You often have to figure it and look at those projects in the context of those historical projects that already exist. And certainly that's been my experience, whether it be in the mining sector, or certainly in the last better part of 20 years, my practice has been a lot of focus on nuclear issues. And the nuclear issues is precisely that, where it's largely happened at the exclusion of First Nations. And First Nations have a long list of concerns and fears about how these facilities and ongoing operations interact with their relationship to their respective territories. And there's no real meaningful movement to try and work to resolve those issues or reconcile these issues. And despite the fact that we have these important tools at our disposal, including the duty to consult, which, if utilized effectively and appropriately, can provide a good pathway for looking at these things. And really, I think from my perspective, creating enough space and time for First Nations to be part of having those conversations, but also working towards resolving those past and ongoing issues in the context of future projects is critical. And so the processes that we have or should have are critical to doing that. And so, if you look at the duty to consult, if utilized appropriately, can be a very important tool for all the parties to kind of work through those issues. But what's important in that is First Nations can't be left behind in that process. They have to have confidence in that process. They have to help shape that process, and fundamentally, that process is doing what it needs to do, which is addressing those substantive concerns and, where necessary, developing the necessary accommodations to address those things. And now we look at what we have in the context of UNDRIP. I'm deeply concerned about where Canada might choose to move that conversation. If you look at Canada's action plan on UNDRIP, nowhere is there any reference or mention to free, prior, informed consent. And I look at, we only really have maybe one, possibly two examples that we can look to in Canada where those processes have been implemented. And I was part of that process, leading that process for our nation. And it took us a better part of 20 years to secure that consent. And certainly early indications are that, from my perspective, Canada seems to be retreating from those principles, right? And I think that's of great concern. And I think, from looking at it through the lens, coming back to the initial part of your question about environmental assessments, if done properly, they can be a very important tool in terms of informing specific concerns that First Nations may have and informing those processes. And more importantly, working towards the necessary accommodations that need to be in place. And now in the context of UNDRIP, helping communities get to a place where they're in the best possible position to have the best information to make an informed decision. But if that seems practical, and I'm sure we all agree that sounds good and makes sense, but from experience, you have to fight for every inch to get that, and that's, to me, is a frustrating part. And what I see playing out now is we seem to be having the same fights over and over. So if I look, for example, in our territory, where we've already established free, prior, informed consent on 2 major projects, and our people have expressed their views on that, and those views have been respected. And now you have Bill C-5, which could now create a scenario where projects could be deemed to be in a national interest. What does that say for free, prior, informed consent? And that concerns me, because you could theoretically have a process, go through that process. At the end of the day, the community expresses its decision on that in the best possible way they can, and that decision may not be respected if a project is deemed to be in a national interest, and that's deeply concerning to me. And so, and I think that's the frustrating part. They keep shifting the goalposts and changing the landscape, and it forces us to have these fights over and over again. I shouldn't have to fight the same fight for consent on these types of projects, particularly with projects that are fundamentally are going to add to a list of legacy issues in our territory that already exist, and we're still working towards resolving those. And so I think that was perfect what David said. It's taking us backwards, right? And if I'm being honest, I'm a harsh critic when it comes to the assessment process we have now. I don't think we typically have done them well. You constantly have to fight to get them to do what they need to do, and like I said, that's a struggle, and there's no guarantee you're going to get there at the end of the day. And so certainly this is not helpful, and very concerning what that may mean for certainly the processes we're in right now in our territory, and what that may mean in the context of how we're going to progress through those things. And certainly right now, we're in no position to go back to our people to say, we're going to have a process that we're confident in, that's going to address the substantive concerns we have, that's going to allow us the time and space to make an informed decision. I can't give them those guarantees, because now they've changed the landscape yet again. And so that, to me, is problematic.
Thanks, Randall. So if I could just kind of summarize what I'm hearing. So there's an environmental review process, and that process is supposed to look at a proposed project and the impact that it's going to have on the environment and on the land. And then as part of that process can take into account Indigenous concerns, and that can be part of the duty to consult. And what I'm hearing from all of you is, there's now these new laws, Bill 5, Bill C-5, that are rolling that back, and that's what's causing the concerns. So maybe I'll get Martin and David to talk a bit about, specifically, what are the rollbacks? What's happening?
Yeah, sure. Yeah, good question, Sen. So first of all, at a high level, the way to look at this is a sudden shift across the country at federal and some provincial levels that share the same kind of spirit and intent to adopt that in this context in a more problematic way, or equally problematic way, to treaty implementation problems around spirit and intent. But the idea here is to, in one fell swoop, through legislation, either weaken or remove, or both, the typical types of, quote, environmental laws that apply to major infrastructure and natural resource projects. So you see that in C-5 at the federal level. You see that in Bill 5 at the Ontario level. There are analogs at the provincial level in British Columbia and Nova Scotia so far, and quite possibly more to come. And so the general approach is you could think of it as both statutory legislative change, but also institutional change. So starting with the latter, one of the key features of these moves is to centralize everything in one office within the bureaucracy, to give these ponies um, exalted status. So they get special treatment by the government who is controlling all the levers. I'll try not to keep going with the pony analog, but you can picture someone riding the pony or trotting it around or whatever, leading it to water and so on. That's at the institutional level. At the legal level, it means things like, I'll stick with actually the federal C-5 because that's one that I looked at more closely than the Ontario one. There is power in the Building Canada Act for the government to actually say these environmental laws do not apply to this project. So think about Fisheries Act isn't going to apply. Species at risk legislation not going to apply. Navigation not going to apply. That's the legislative power. But Impact Assessment Act, Federal Impact Assessment Act, the well-known C-69 to adopt that initial naming of it, may not apply. But to be clear, those laws do still apply under the federal approach. It's just that when a specific pony comes along, there is power in the statute for the minister to say, okay, this one we want to give it the easiest ride possible, and so these laws don't apply. And so just to walk through the basic mechanism of C-5 really quickly, you could think of it as like a 4-step process. So step one, proponent comes along and says, I've got this pony that I want to propose to put it on the list using the criteria set out in the Act, and with at least a legislative commitment and constitutional responsibility, the federal government will consult on whether or not that pony will be on that initial list. Assuming it does make the list, and examples right now might include the Grays Bay Port and Road project in Nunavut, the Port of Churchill upgrading, offshore wind in Nova Scotia, and if you're in Alberta, somehow this magical new pipeline to Tidewater. If on the list, then right off the bat, there's an early green light issued by the federal government that deems that all federal authorizations and determinations and opinions and so on, there's really broad language in the statute, are deemed to be, quote, in favor of the project. So that's this early green light, and that's why you see the Carney government saying this is not about whether a project will be approved, it's about how to build it. So that early green light takes the whether off the table and leaves it in a how track. And I'm sure we can get into what that means in terms of respectful engagement with Indigenous communities and whether or not FPIC is even on the table. But just continuing to walk through. Then there's some time will pass where the proponent actually has to do everything in substance that would otherwise be required under applicable laws. So, for example, fish habitat mitigation, navigable waters aspects, species at risk aspects. So to the extent that those laws have not been suspended, given those ministerial powers, then the requirements of those authorizations must all be fulfilled. And at the end of that rainbow, if you can picture My Little Pony and all the rainbows that sometimes happen in that cartoon, at the end of the rainbow is this pot of gold that major project proponents have been looking for more than a decade, if not decades. And that is this all-in-one authorization that is another green light that has all federal authorizations in one place with mandatory binding conditions. And so, whereas in the past there would be a green light under, say, an environmental assessment and impact assessment process, and then other separate green lights issued by other departments for things like fisheries, species at risk, navigation, and so on. That's now all in one centralized document, which may or may not, I mean, in theory, that could be a good idea. It's certainly what proponents have asked for. But even from a transparency and accountability perspective, if done right, that's actually quite helpful for the public and for civil society in terms of oversight, accountability, and so on. Anyway, that's the basic linear process, and then you're off to oversight and implementation, as typically policed by any given federal department to make sure that conditions are being met. There's some open questions about what that looks like, but that's the basic structure. And so last point I would make before Martin hops in is to say, this is all about what projects are on that list. If it's 5 projects where everyone in the nearby and not even nearby communities is supportive of the project, including Indigenous communities who hopefully have an equity stake, if not complete leadership, like Cedar LNG, for example, as an example of an Indigenous led project. And the proponent is there, and the governments are there, and the provincial government's on side, just tailwinds blowing all the way, then it may not be that problematic if it's just this small list. It's really going to come down to what's on the list. But most signs are pointing to a longer list than 5 projects where there will be acrimony, including and especially on the side of Indigenous nations who are concerned about constitutional rights and so on.
Martin, you got anything to add to that?
I mean, I think the one thing I would add, I think that's definitely covers it. I mean, I think the important thing is about that master authorization. The thing to understand too is what the Act says essentially is that not only does it it's deemed to sort of stand in for all those authorizations, but they went further and they also said that it's deemed to meet all the requirements of all those other enactments. And so this is something that we've had some discussion about. I mean, what it would seem to say is it creates the legal fiction that, if we think about all those environmental laws like impact assessment, like the Fisheries Act, like species at risk, for the most part, the species at risk, maybe you could say, does create a bit of a hard bottom line, but for the most part, these are discretionary processes with guideposts, right? So we just ask the government to, for instance, consider the precautionary principle, or we say you have to consider Indigenous knowledge, and you have to adhere to the principle of scientific integrity, and you have to consider cumulative impacts. And none of that means you can't make the decision that you want to make, but it's intended to create in a sense, constraints or guideposts to move the decision towards, and the project towards a more sustainable form, right, from an environmental perspective. And a lot of environmental law litigation basically is when a project's been approved or a permit's been issued, we say the minister didn't comply with their duties, right? Environmental law is inward and outward facing, and this is the inward part where we try to force governments to sort of adhere to these different constraints. And so by deeming all these requirements to be made, I think a pretty strong argument can be made that essentially these authorizations are not reviewable. Like they will not be subject to judicial scrutiny, with the important exception of, some kind of constitutionally rooted challenge, inadequate consultation or some other Section 35 type argument. And so that's a really radical departure, right? And so then just tying back to what Dave said, I mean, I think if this is a small list, if the first tranche of projects is a list that, that is about really just like the moving good projects forward, then maybe this will be okay. But if we get into a contentious context, and I can't imagine, some proponents have to see the prize, and people are going to push to get their projects on here because essentially we've created now a 2-tier system, right, for project review in the country. Like that federal office, that new federal office that's supposed to manage all this is going to be an incredible pressure cooker. And I don't know, I'm not sure that this government appreciates just the level of pressure and scrutiny.
And just for the benefit of our Ontario listeners, there's also Bill 5, which I think the most remarkable feature of it is a version of what Martin, you and David have been talking about, which is creating a set of exceptions that they're calling special economic zones. So, of course, that's an idea borrowed from the People's Republic of China from the late 1970s of kind of creating geographical areas within the country where ordinary laws don't apply. And so now there is the power of the Ontario government to do that within any area of Ontario that it sees fit, and to exempt the application of any provincial or municipal law. So that's the slightly different Ontario version of things. So I want to kind of, yeah.
If I could just, so just to say, because I can't believe we haven't talked about it yet, but yeah, so these are the Henry VIII powers, right? These are these like king-like executive powers to take the laws duly passed in the legislatures and to amend them by executive action. And it's, again, a really radical departure from
of course, Henry VIII is that beloved early modern monarch of England. That is the subject of Netflix fame. So I want to take us back to what you all of you were alluding to, which is, well, these exception creating laws are creating exceptions to environmental laws, but they can't create exceptions to Indigenous rights, which are part of the Constitution. So I want to hear all of you talk a bit about where that leaves the duty to consult. So in the old days, we had the duty to consult being fulfilled through these environmental processes. And I guess if there's going to be exceptions, if some of these processes aren't going to run anymore, or they're going to be deemed to be fulfilled even without running, then how is consultation going to happen? Who wants to take a stab at that one?
Randall, why don't you lead if you're open to
Yeah, sure. Give me the tough question. No, no.
I don't know seems like a fair answer at this point. Also,
I think it's going to be. Yeah, it's. I think the comments earlier about I think is correct that it's unknown. We don't know what's going to be on this list. Or how that's going to play out. And I agree. I think Martin had said that, most definitely a lot of proponents will be lobbying to be on that list, and I expect it'll be definitely longer than 5 projects. And, that's of concern for us in our territory, given the nuclear issues we're dealing with and addressing right now. I would totally expect that's where a lot of proponents on the nuclear side would be pushing those things. And certainly early indications are those that could be the case, and that could be aligned with what certainly Carney and his party have been saying, and the government's been saying that we'll prioritize those projects that not only beneficial to Canada, but can also help us meet some of our other targets, including climate change initiatives, right? And we know that Canada, for the first time in a long time, is really investing heavily in nuclear, right? They're doubling, tripling down on it. So it'll be interesting to see where that plays out. I think, we can't look at these things necessarily in isolation of what I would say, Sen, is just in the context of duty to consult. There's other moving parts here that obviously will factor in, and that includes UNDRIP, particularly around free, prior, informed consent, and what that may look like and how that's going to play out. And so, we don't know where Canada is going to stand on that. We can look at kind of case-by-case scenarios. I gave you an example earlier what it took us. It took us a better part of 20 years to try and to get to that place and correct course and get Canada to recognize that was the direction we needed to move in. And through that process, the minister had a discretion to go there, and we went there, and fundamentally Canada ultimately respected the decision and the outcomes of our process. But early indications are now that seems to be shifting. And I've been in a number of meetings now where I've heard reference to consensus or collaborative, and this use and doubling down on language that it's not a veto, and that there's no you have no guarantee of an outcome. And those are none of the things that's my nation or our people have said in the work we have done. We've always said, at its core, FPIC is a process. It's rooted in self-determination. Fundamentally, that process belongs to the collective. It belongs to the people. It didn't belong to me as a chief. It didn't belong to my council. It belonged to our people. And our people would exercise that decision through whatever processes or mechanisms that seemed appropriate to them. And so our task, both as in a leadership role and as advocates, was to make sure that we created the time and space for them to be able to consider what is being proposed and fundamentally come to an informed decision and make sure that at the end of the day, Canada and industry respected that decision. And so that took a lot of time and effort to do that. And when I hear these references to how the language that's being used, it caused me concerns because it seems to be a step back. And why would I accept a lesser standard than we've already spent the better part of 20 years fighting for? So I think there's a lot of other factors that come into this. And, it'll be interesting to see how, I think everyone's going to be watching closely how the Quebec case plays out. Because that's one of the first cases dealing with consent. And we'll see how that plays out early. Some of the things we're seeing and hearing now is that, consent is just a consultation process on steroids. And at the end of the day, it can't. And I'm not making this up. This is a language I've heard utilized in those discussions, is that we can't establish a process or have an outcome that feathers Canada's sovereignty. And from an Indigenous perspective, that's a bit offensive because there's a presumption of Canadian sovereignty. There's never an acknowledgement. First, I can't speak for all First Nations in the country, but I can certainly speak about our experiences and our lived experiences in our territory. We weren't a conquered people. We never surrendered our jurisdiction or authority to the Crown. And certainly have never abdicated that to Canada. So there's a presumption of Canada's jurisdiction and authority. But certainly that's something we've never accepted. And so, as you can imagine, a lot of First Nations take offense to that. So I think a lot of this will depend on how all these pieces are going to fit together. And I don't know how we do that when you have something that's been so rushed. And I think this has been the concern for a lot of leadership and First Nations. It's been a very rushed and insular process with no opportunity to get certainty around some of these things. And so in the face of that, where does that leave you, right? And so, and for communities like my own who've been doing this work now for a long, long time, and we finally get some progress, you wonder where that's going to take us at the end of the day, and that all that work could be for nothing. And then we have to have another fight about something. And I think that is deeply concerning. And so for this to be, even be remotely effective, those processes are going to have to be designed to do what they need to do. Their First Nations have to have confidence in those processes. Those processes can't feel rushed or insular. And fundamentally, at the end of the day, it has to address their substantive concerns. And fundamentally, it has to acknowledge and respect that those First Nations have a right to consent and a right to have those decisions respected. And so, that's the thing. And I don't know how that's going to look in the context of what's being proposed now. I don't know how you get there if no one's taking a pause and really stepping back and thinking about what those processes need to be. And I think there's a presumption that when I hear some of the comments that are being made about this, at least at the governmental level, there's a presumption that all those processes are somehow perfect and they're working. And we haven't even talked about those, right? And so I can talk about my experience at the Commission, for example. There's a lot of deficiencies in those processes that may not necessarily be conducive to reconciling the very issues that First Nations need to reconcile around those particular set of issues, right? And the nuclear process it's a complicated process, right? It's a long process when you think about it in the context of mining and processing, through to operations and through waste management, whether it be interim or permanent waste storage. It's a huge cycle, and these are forever projects, right? They're not just like one generation it's done. These are generational projects and forever projects, particularly in the context of waste. And so that gives you some sense of the certainty that First Nations would have to have around these particular projects and proposals. And that can't happen if the process is going to be rushed. And somehow Canada is now going to wield a hammer over First Nations and say, well, this project could be in the national interest, and we'll sort the rest out later, right? And so that I think is, for me, is of real concern. And so if the processes, there's not enough time to really think through and build out those processes, and First Nations don't have confidence in those processes, then I think you're going to get resistance. I think you're going to get conflict. And I think you're going to get the exact opposite of what these bills are designed to achieve. I think you're going to get a lot of delay. And one of the questions I was asked in the Bill 5 committee hearings was what I thought was going to happen in that regard. And I said, well, listen, you assume I have to stop you. Your only fear is that I can stop you. I don't have to stop you. I just have to slow you down. And I have enough tools to do that. And a delay to a project, a significant project, whether it be months or perhaps even longer, that's a significant consequence to proponent and whatever the Crown may have planned. And so, and I think that's what everyone's losing sight of. And I think, to me, it's just counterproductive. And like I said, I'll keep coming back to that point. The frustrating part for me is that then I got to have the same fights over and over again and win back the same points I've already won in the past. And I think that's the frustrating part. And I totally understand when a lot of chiefs now are saying they don't want to play that long game. They're frustrated, and you've heard some reference to kind of, I don't know, more 2.0, and I get it. I totally get it. And so I think there could be another side to this that I don't think Canada has really contemplated. And that you could have a scenario where the exact opposite could happen if this bill moves forward unchecked, and you're going to have a lot of resistance. And I think, unfortunately, is conflict. And the courts are going to be pretty busy on this stuff. Yeah.
Thanks, Randall. And you referred to the Quebec case. We will put a link to that in our episode description. David, I think you wanted to jump in.
Yeah, I mean, excellent points, and I think Randall's done a great job of crystal balling and articulating the deep concerns. I'll just add a couple of bits. I mean, one is, as you acknowledged at the outset of this question, Sen, really, this is new legislation, but it's not a constitutional amendment. And so for the bulwark here is the Constitution, because you can't legislate out of it. And for better or worse, Indigenous communities of Canada, of today's Canada, are now tasked with, in some ways, having the strongest tool to safeguard proper implementation of this act. So that's a huge thing to add to the huge list of responsibilities and resource intensive nation and institutional and administrative and technical work that Indigenous governments are already tasked with. But just a couple bits to try to answer your question about, like, where is the duty to consult now? And one thing that I've been thinking a lot about is going right back to the landmark Supreme Court of Canada case, the Haida case from 2004. And of course, paragraph 51 says a lot. And I'm just going to take 1 second to read that key sentence. It's open to governments to set up regulatory schemes to address the procedural requirements appropriate to different problems at different stages, thereby strengthening reconciliation and reducing recourse to the courts. So basically what that case and application of the case has meant for more than 2 decades is courts will defer to governments' administrative processes that they use to fulfill the duty to consult. And so in some cases, that deference is going to live on. But that doesn't mean that the constitutional rights don't still exist. The next sentence of that paragraph is actually more at issue now, and I don't think has received as much sort of interpretation over the years. The government may not simply adopt an unstructured discretionary administrative regime which risks infringing Aboriginal rights, that's the old terminology, of course, in a substantial number of applications in the absence of some explicit guidance. So there is a guidepost there, and a big question with C-5 and Bill 5 is this so thin and so weak and so open-ended and so discretionary that courts are not willing to give deference to these situations, to this legislation, these new legislative schemes. So it's interesting to see. Again, I think it does still come back down to which projects are going to be on the list. And I think one of the ways you were framing your question too is, where does this leave Indigenous jurisdiction? It's actually not hard to see one of these ponies being in that Goldilocks zone. where it's Indigenous led, it is an Indigenous nation building project that is in line and in pursuit of that Indigenous nation's direction towards self-determination. And things can go forward relatively smoothly. That's going to be a really small number of cases, but that is the sweet spot here, right? When the problem, last point I would make is that the problem over the decades is that government proponents come along in a transactional way and say, we have this single project that we want to advance, let's talk about it. And an Indigenous community, and this is, I think, many of the excellent points Randall made, would say, well, that's nice that you want to talk about this. What we want to talk about are the many past harms and what the future looks like in terms of nation building for this Indigenous nation and self-determination. That's not off the table in these contexts. There's just a lot less legislated structure around it.
Martin, I think you want to jump in.
I mean, I'll just go back to, I'm going to make just the pragmatic argument again. So, so I think what we're all acknowledging here is essentially that we're talking about, well, there's already so much to be done, and we seem to be compressing the space at the time in which all of that can be done. And what I will just add to that then is that, to varying degrees, but I think actually like to a fair degree, whether it's myself, all of us here, all of the lawyers who work either at, at the companies and the proponents that are going to bring some of these projects forward, or in the First Nations, we've all become accustomed to and familiar with the current environmental law regime. And so one of my actually big concerns with this ability, whether it's under Section 7 to essentially deem requirements to be met when they are not in fact met, or to use that Henry VIII power, is that you've eliminated the baseline that we've all built already and understand in terms of the current how to approach a project, what are going to be the requirements, what are the, on the federal side, what are the Fisheries Act requirements more or less, what are the navigable waters requirements, what are the species that, everybody knows these things. And so then that creates a starting sort of like a baseline or starting presumption, and we just work from there. But if now suddenly the federal government is prepared to renegotiate those standards, then you have all that much more work to do, actually. You've actually made this more difficult because suddenly we're going to be talking about different standards, and so, and I will say, maybe, going back to, the idea of a Goldilocks project, I mean, maybe they're never going to use these things that way, and I have some sympathy for the government's position. We were just talking before we started here that, Trump has just announced that trade talks are off with Canada. That was, and who knows, he might take it back again, but that apparently he's quite upset about, the digital services tax or something like that. I mean, it is possible that we are in for a very difficult ride economically. And it's possible that the government simply, having recognized or accepted that there's been a massive branding problem with the Bill C-69, with the Impact Assessment Act, and referring just quickly to my work on the Mine Act, we in our last report to the minister that was tabled a couple of weeks ago, we said the act appears to have been a victim of a self-fulfilling prophecy. Whether you call it the No Pipelines Act or whatever you wanted, whatever branding came from other quarters, there's a perception that the act inhibits movement, project development. And the government, I think, simply said, look, we need to do something, even if we, to send a signal. And C-5 does send that signal. And so then the question just becomes, is it going to be used as are the radical powers there going to be used really? Or are they in fact, like really just about sending that signal, and we're going to see a government that, like again, the Prime Minister has said, like, I'm going to do this the right way. And so I think that's the fine line here and the difficult balance for the government is that they are trying to send a signal to the markets and to investors that it's time to build. But they also want, they want to be able to say that they're going to do this in the right way. And that is, again, that's a very tall order in this context.
Appreciate all of that. I want to put my proponent hat on for a second and kind of think through some of the points that all three of you have been making. So, I want to build a project. The thing that I want is certainty. I want to know, this is the year that I want the capital to come in. This is the year that I start building. This is the year that I start selling those critical minerals into the global market. If I'm going to spend tens of billions of dollars on a project, I would like to know what that timeline looks like. So how does this help? How do these special powers help me if I have my proponent hat on? And I'm also thinking about, you know, I think in many ways the environmental impact assessment project has been used as a way to cover off, to put on a fig leaf over the lack of FPIC, the lack of Indigenous consent, by saying, well, you didn't consent, but you got consulted anyway because we had this big, long environmental process. And so if you don't have a big, long environmental process, then where's that fig leaf? Or if something ends up going wrong with your mine after you've built it and there's a giant, terrible spill of some tailings ponds or something, I think, if with my proponent hat on, I would say, this was a terrible tragedy. We followed a world-class environmental review and imposed all these conditions on it. We followed all of them. So this is just a tragic outcome. But if they've managed to skip those environmental processes and there is a giant spill, then what do they say? Where is the social license? So I think where that gets me is, if I'm a proponent, why do I want this? Why do I want my project to be imbued with these special powers? Why do I want them to be ponies?
I'll just say that I've heard anecdotally from a few folks in the industry that they actually don't want anything to do with these designations, that they would prefer to stay far away from them. And in particular, the special economic zones, and I won't profess to know exactly some of their thinking, but I think it's along the lines that this will actually encourage antagonism, like hostility, concerns, right? And so that I think a lot of proponents would say, we'd rather just work in the background, frankly, like we've been working, like the vast majority of projects have been working in the background without any kind of fanfare and without any contention. And it's only really been these a handful of contentious projects that get wrapped up in sort of these broader discourses and opposition and all that kind of stuff. I mean, I think the only other comment I'll add here is that it's interesting, of course, that Bill C-5 anyway certainly doesn't make any commitments, doesn't actually contain any hard deadlines. There are no timelines in the legislation, and so we've heard that I think 2 years is the sort of goal. We know that the agency is working towards a 2-year review timeline internally, regardless of whether this project, whether C-5 applies or not. So there is certainly there seems to be a strong desire to move faster. But whether that happens or not, it looks like the government's at least aware that that's a tall order, and it wasn't prepared to bind itself legislatively that way. And then finally, I'll just say, stay tuned for essentially punting on some of these difficult issues. It will become, and I hate to use this term because it's been so misunderstood and poorly used, but we know that proponents have relied on the vague promises around adaptive management to sort of like punt the identification of effects or their mitigation. And I think we're going to see that in a very robust or like a very heavy-handed way, because there simply won't be enough time to do these assessments in a really thorough way.
I could hop in. So your question really is, if you're a proponent, why would you want this? And what's the likelihood that you're going to actually get what you want out of this? So, I mean, one clean part of the answer is, I want access to that major projects office. Right. I want this exalted status. It's like that old George Bush quote when he created FEMA. I'm the kind of guy that just wants to make one phone call to one person and figure it all out. Right. So there's probably that mentality. And, if this institutional aspect of all this goes as planned, it will be like that. And Big Boss Major Projects Office will be able to call the line departments and say, look, we need clarity on this right away. So that's attractive, full on, just to adopt that lens. That's setting aside all of like the broader backfire risk that I think you're touching on, and that Martin's laid out. I mean, I think just a good way to look at this is through a recent history lens. So the Impact Assessment Act, C-69, was born basically out of the Idle No More movement and born out of the Harper government's shifts to weaken federal environmental laws, including the Impact Assessment Act. When the Trudeau government was elected, the logic was we've got fires, the political fires burning across the country on all kinds of fronts. Let's bring that all into the statutory process so that we at least have a forum and certainty for everyone, from Indigenous nations to environmental organizations, civil society to proponents. And then we at least all have, like, we know the edges of the sandbox, and we can get to work together. The shame here is that there really wasn't enough time for that to happen. And so that was experimental in a way, and we never really get to see the results of that experiment, or it's looking like we won't get to see the results of the experiment. The travesty in all that, I think, is that credit to the mining industry for not being completely anti C-69 throughout, but the oil and gas industry more or less was anti that throughout. And to talk of self-fulfilling prophecies, that really was the case. I've written before that the implications of the Impact Assessment Act for oil and gas and Alberta energy projects need not be fatal or dire. Rather, that set a legislative scheme in place that allowed one to showcase how good a project it was, the benefits of that project, while minimizing the adverse effects. In the present context, that's more or less off the table, partly, as Martin said, because we just had to do something, or there was a perception that we had to do something. What the future looks like in terms of whether or not some of these projects will mean suspension of the application of the Impact Assessment Act for a particular pony remains to be seen. And it's, again, all going to come down to those specific projects.
Randall, anything you want to add here?
Yeah, no, I think those are all very good points, and I think it's going to vary from proponent to proponent, right? I think, and from sector to sector. I imagine there are some who would love to have that status and will feel that, let's look at the least path of resistance here. So if we can get our project on that list, then we're that much further along the trail, and at least we have Canada backing us, or at least some presumption that they're going to back us. And I think it really comes down to, where all this uncertainty exists around what the processes are going to be coming out of all of this, right? And so that's an unknown. I think from an Indigenous perspective, it's, it feels very rushed, very insular, and there's a lot of uncertainty there. And, some proponents are going to want to play the game, and some are not going to play the game, right? And so that's certainly had been my experience. And so, and some of the challenges I've put out to industry, at least in the context of the nuclear industry, when I was a commissioner, I'd ask point blank, what are you doing to implement Call to Action 92, which requires industry to, as part of a reconciliation framework, to adopt UNDRIP and including consent-based decision-making in their processes, and looking to reconcile those, what I'll call legacy issues, with First Nations, at least in the context of the nuclear aspect of it. But what happens if you have a proponent that is not willing to do the right thing and work with you? Then you have to look to the Crown, because it's the Crown that carries that, as David said, the constitutional obligation to make sure that First Nations rights and interests are being protected and safeguarded through whatever process that need to do that, whether it be duty to consult or otherwise. And so, who's going to do that? And so I think that's where all the question marks are, is, where is the Crown going to fit into this? In a perfect world, we'd have these processes that work and do all the things they need to do. But we know that each time you get into a process, and I'm sure we'd all agree, it's a fight every time on a process. And I think there's a presumption that, and I think this is one of the things that governments are particularly guilty of. They forget that we're diverse. First Nations in Canada are diverse. We have our own unique experiences. Those experiences are shaped by our broader relationship to our territories and our lands and our waters, and the various things we've dealt with in our history. And no two First Nations are the same. So what works for Haudenosaunee, what works for Mushkegowuk, what works for Cree, may not work for my people, right? And so and I think there's something, David, you had said earlier, and I thought it was a good point, and I come back to this. I think my experience in the work I've done over the last 25 years, there's always this presumption that First Nations are somehow anti-development. And that's my experience. That hasn't been the case. I think they want to obviously reconcile those things that exist in their territory and have some certainty around those things and how those things have interacted with their broader relationship, and including the environment. They want to reconcile the missed opportunities that exist. I remember the late Chief Alfak Wenzi used to say, we shouldn't be beggars in our own land. We should never be left on the outside looking in. And that makes sense, because you look at historically, at least in the context of our people and our territory sustained us in many different ways, including economically. We had a thriving trade economy as part of the Three Fires Confederacy, and that's what sustained us. And so we were very conscious to protect that broader relationship to our lands and waters for that purpose. And so, everyone seems to fail to appreciate that this takes work, and that, we need to shift how we do these things, including creating opportunities, as David talked about, where projects can be done in a completely different way, where First Nations can move forward with confidence and actually build out projects that are going to make sure aren't impacting their interests in a negative way, and that they're in the best possible position to benefit in a way that's really meaningful, however that is, whether it's through some type of IBA or equity participation, however they choose to take that space. And so, but that takes time to build that out, and you need industry and you need government willing to recognize that those require processes, and you can't apply one size fits all, right? And so the unique challenges we have with the nuclear issues in our territory are going to look fundamentally different, perhaps, in how First Nations address those issues in the mining sector and uranium mining, right? And so what works for them isn't going to work for us on the operations side and the waste management side. And so, that's why I think it's important to think about what the process needs to be, and that's where the uncertainty, I think, exists. At least in a nuclear context, this issue of kind of shortening timeframes or trying to have a much more efficient process, that's their language, not mine. That's been in discussion for a while. In fact, there's been this push to make the commission as a life cycle regulator. They should be doing what's dealing with nuclear projects, right? And so that would essentially do away with integrated assessments, and CNSC be one-stop shopping for nuclear industry, right, to do what they need to do. And so from an Indigenous perspective, that's problematic, because you already have a mandate that's quite dated, and it's not conducive to speaking to a lot of the things we're talking about here now. And David made the point earlier about creating opportunities for those partnerships, letting that inform part of the discussion and the process, and fundamentally the decision side of things. There is no socioeconomic analysis within the commission framework, and so that's a real deficiency. So, this, now we're talking about a 2-year time frame, right? I've heard different conversation. You went from 5, then they wanted to go to 3, now it's to 2, right? And so it's always this moving target. And so I think those become issues that are of great concern, and the uncertainty on what the process need to be. So, I think a lot of this is going to depend on, it's also going to be dependent on the proponent. There are going to be some who are willing to play the game, and maybe they have a different moral compass than others, but it's going to vary, I think, from sector to sector. And but if I'm a proponent, and I'm going to be looking for certainty, but I'm also going to find the least path of resistance too, right? And so, and I think that's the unknowns on this, and I think it's going to vary from sector to sector.
Thanks, Randall. I think we have time for just one more question, and I want to end on a hopeful note, or as hopeful as we can be in these circumstances. So I kind of want to take the lead from the kind of relationships that all of you have been talking about between Indigenous communities and their land, and potentially supporting projects that make sense from their perspective. And so I want to bring an example in from the protection of burials in Ontario. I think, the lack of provincial participation in the protection of burials has meant that a lot of First Nations have just taken the lead on that kind of jurisdiction. And so the Crown might be calling it the duty to consult, but the proponent knows that when they've found a burial, unless they get consent of the First Nation, their project is potentially in great jeopardy. And so while the Crown calls it duty to consult, it ends up being kind of like a consent right. So I want to ask all of you about this possibility. So, if we're talking about the provinces and the federal government maybe on an exceptional basis deciding that they're going to evacuate environmental jurisdiction, does this create an opening for First Nations to reinvigorate their Indigenous law jurisdiction, to say yes to the projects that make sense to them, to impose conditions that make sense to them for the projects that are being proposed for their territory?
I'll go first, I guess, just to say, and I'm going to shamelessly sort of like, at least my own answer is going to reflect the work that I've been working on and thinking about a lot lately. And that is, I think, yes, but in particular, I think, in terms of to take a regional perspective, right? So I think land use planning actually is going to be a big part, could be a big part of the solution here. I think that if Indigenous peoples throughout Canada, and I know they have this capacity in some places, actually, in British Columbia, I think there's all kinds of like really interesting and progressive things happening. And obviously in the North, that's an ongoing sort of effort. But I think if First Nations take that approach where they say, okay, this is our territory and this is how we want it to look, this is how we foresee development, then that becomes their starting bid, I think, for when proponents and governments start to think about their own projects. And for sure, that vacuum, I think, it's a very interesting perspective, of course, right? Because I think we can think about traditional constitutional doctrines like paramountcy and whatnot. I mean, conventionally we know that federal laws are paramount to provincial laws, but we've talked, I think, only speculated in a sense on how that's going to play out, as we start talking about Indigenous resurgence of laws and land use planning regimes. But of course, if the federal government is vacating the space, then there's really nothing to conflict. And that's maybe a bit of a simplification, but I think, to just answer your point, I think, yes, I think that's absolutely the case. I think there is a real opportunity here. It does present itself here, and for various reasons, the more of that work that Indigenous peoples will do and can do, I think it will have more bearing and more influence in these discussions, whether it's the pony regime or even just other projects more generally.
Thanks, Martin. Who wants to go next, and who wants to have the last word?
Go ahead, Randall, if you want.
Yeah, no, I think that's Martin's made a good point. Short answer, I think absolutely there's we create an opportunity. Stepping back, I think what I would say is, from my perspective, this is work, though, that a lot of Indigenous communities have been doing for a long, long time, and trying to, in essence, put the square peg in a round hole, right? In the various assessment processes we do have. And, I think there's been some positive movement there in terms of how we bring that perspective and those issues into the context of an assessment process, and making sure fundamentally they're safeguarded and they're respected. And I think that's always the challenge. And one of the things I've always cautioned, whether it be regulators or the industry, is you can't just throw Indigenous knowledge around like it's candy. You have to respect that with that there are certain things implicit in that understanding of sharing that Indigenous knowledge that you have to understand and observe. And first and foremost is you have to observe the protocols and the parameters for how that information is even shared, the conditions under which that knowledge is shared, and the parameters around that, and fundamentally how that's going to be considered in a context of the assessment process. You can imagine First Nations not wanting to share that knowledge, and it's not going to be heard or respected, and it's not going to be put on that equal footing. And so, we've seen some positive movements on that. And so, some communities have been doing a lot, like I said, a lot of work on this. And so, if there's an opportunity to further enhance and bring those issues forward, enhance that jurisdiction, I think that could be a good thing. It's just making sure at the end of the day those are there. And there are good examples where projects have been designed and developed in the context of with those principles, right? Few and far between, but certainly there's an opportunity to see more of those. And I think that will require, First Nations continue doing that positive work and doing that work in a good way, but also make sure that you have proponents that are willing to respect that and understand that and bring that into the conversation and recognize if they want to build a project, that's the way they're going to have to do it, right? So, there's most definitely, I think, opportunities there to build on that and further that jurisdiction and that work.
Thanks, Randall. David, I'll let you have the last word.
Sure, I'll try to be brief. I mean, I think the way you're trying to close the session here, Senwung, is to do it on a hopeful note. And it's hard to do because even if you can find opportunity in these bills, it's the process, the rush process through which they were brought in that's deeply problematic. And there's no going back. Like, that has happened. And there is a precedent there for this government and future governments that is a way to do business when the geopolitical dynamic somehow justifies it. And that's just, there's no undoing that, which is problematic. So sorry to rain on your hope parade, but I will close with hope, and that is there is a legal vacuum, or what Jocelyn Stacey at UBC has called legal black holes in this context, and she's got an op-ed in the Toronto Star that your listeners would probably enjoy reading. But in that black hole is opportunity. And so there is no rule here against Indigenous-led impact assessment. There is no rule, to Martin's point, there is no rule against Indigenous-led land use planning here. And of course, up north in the land claims agreement context, there are constitutionally required land use planning processes, which is a good thing. There's no rule against a Tahltan nation-style consent agreement, which you see in the BC context, in the context of the Red Chris mine. So it's difficult because that is very resource intensive for any Indigenous community, Indigenous nation, Indigenous government to take on. Yet, if there is somehow miraculously the resourcing, gumption, wherewithal, and so on to do so, then this can be a space that can be taken up by self-determination, nation-building projects that are led by the Indigenous nation, and there's a huge opportunity there for some, and it's never waste a good crisis. Well, I see your crisis and raise you this crisis, and see it is the approach that some of your listeners may be thinking they want to take.
Well, thank you very much, David, and thank you, Martin, and thank you, Randall. Really appreciate all of your perspectives on these important topics. I think it's been really generous of you to share your time with our listeners and to share your thoughts and your wisdom. So with that, I'll close off this episode and say thank you to our listeners for tuning in. Keep your eyes peeled for further OKT podcasts where we bring you insights from experts on the latest Indigenous rights topics of the day. So thank you for tuning in, and hope to have you guys check into us soon. Thank you.